Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are back with the government's response to defendant's motion for a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure. And so this is the response to Jennifer Bonjean's motion that she filed last month, and this particular motion is 45 pages long, but let's start. The table of contents is one page, and then they have a table of authorities, which is all the cases that they are going to cite in this motion, and it is 3 pages long. And then we get to the introduction, which is on page 6, and that's where we are going to begin with this. So it says the defendant seeks a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure, Rule 33, as a result of his conviction on September 27, 2021, of 9 counts charging racketeering and multiple violations of the Mann Act. In his motion and supporting memorandum, the defendant argues that he, one, was denied effective assistance of counsel because his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, and 2, was denied conflict-free counsel under the Sixth Amendment because one of his attorneys simultaneously represented the victim who testified at trial under the pseudonym Jane, who we also know as Ariel. For the reasons set forth below, the court should deny the motion in its entirety. And let me stop right here because I realize there may be some people watching this video going, what in the world is she talking about? So this is the appeals phase of the case of the Eastern District of New York versus Robert Sylvester Kelly, who's also known as R. Kelly, the king of R&B. You guys know who he is. And so he was found guilty on 9 counts back in September of 2021, and so he has gotten rid of all of his lawyers and has brought on a new attorney by the name of Jennifer Bonjean, and you may have heard Jennifer Bonjean's name before because she is the attorney that successfully argued the appeal for comedian and actor Bill Cosby and had his conviction overturned, and he is now home as a free man. And so she has filed motions regarding this case, and you can go back and check out more information about her motions and about this case in its entirety. It has been going on since 2019. He was arrested by the federal government in July of 2019. And he sat in jail for over 2 years before his trial started. And it went by pretty quickly. The verdict came back pretty quickly. And so now we're in the appeals phase where Jennifer Bonjean is asking the judge over the case, Judge Ann Donnelly, to either vacate the verdicts or to give him a new trial. And throughout the case, Ann Donnelly has been very biased. I mean, she thinks she's a hard-nosed attorney, and there were moments. Now, I honestly believe that during the trial, she was fair on both sides, but she did do a lot of questionable things, like she prohibited the release of transcripts to the general public. until she was able to read the transcripts and make redactments in the transcripts because she didn't want certain information getting out. She said that she was going to have additional courtrooms available for the public and for the media. And then we learned that there was one courtroom for reporters, and they had maybe 30 reporters. And then there was another courtroom for spectators, but rumors were, or it may be factual, that only about 8 people were allowed in the spectator room. Not sure why that was. And then just a lot of craziness. Lawyer Gloria Allred was allowed to go into the actual courtroom where the case was being heard when she had clients that were testifying in the case. And there were a lot of bad acts witnesses in the case. And that's one of the things that Jennifer Bonjean is also arguing you should not have been allowed. There were 5 actual people. Well, actually 4. There were 5 alleged victims. 4 of them are living. 1 is deceased, and that was singer Aaliyah. But then they had a slew of bad acts witnesses, which are people who claim to have experienced behavior by Mr. Kelly that was used to bolster the case that the government had against him. And I think that Ms. Bonjean eloquently relayed the message that it was merely a reenactment of the docu-series, if that's what you want to call it. That term is used too much, but it was a dramatization of these women who are allowed a platform to tell unsubstantiated stories and put out to the public. And then we learned that many of the jurors in the case had watched Surviving R. Kelly's and had already formed an opinion before actually going into the courtroom. And so I have a playlist called the R. Kelly playlist, and you can definitely find a lot of videos. I believe I have over 100, I know close to 200 videos about this case since it all started in January of 2019 when Surviving R. Kelly actually was released on Lifetime television. So we're going to go ahead and get into this, because after I read this, there's another motion that they filed, or response that the government filed, that is 109 pages long. So go check out the R. Kelly series if you want to see. I don't repeat my content. So once I talk about something and put it out there, chances are, unless some more information has come out, I don't go back and repeat that same commentary over again. You just have to go to that playlist, R. Kelly playlist, or you can go to my homepage of A View from Tracy's Point and click on videos, and then you can bring up the different videos that I have done on this case, because there may be some that are not in that R. Kelly playlist, because I found that when I put them in that playlist, they were more likely to be flagged by YouTube, which is a whole nother story. But anyway, let's continue with the Eastern District of New York's response to Ms. Bonjean. So 1, applicable law. Rule 33 provides that the court may grant a defendant's motion for a new trial if the interest of justice so requires. And this is for Federal Rules of Criminal Procedures 33A. However, motions for a new trial are disfavored in the circuit, and the standard for granting such a motion is strict. And this is United States versus Gambino, Second Circuit, 1995. Accordingly, courts must exercise their Rule 33 authority sparingly and only in the most extraordinary circumstances. United States versus Sanchez, which was heard by the Second Circuit in 1992. So they're basically telling Judge Ann Donnelly, don't pay this any attention. Don't pay Jennifer Bonjean any attention, and just totally disregard what she has put out, in her motions. So, part 2, the defendant was not denied effective assistance of counsel during voir dire, and voir dire is jury selection. The defendant asserts that he is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve on the jury. This claim lacks merit. So, relevant background. In order to facilitate jury selection in this case, approximately 575 prospective jurors completed a comprehensive 28-page questionnaire comprised of 108 questions. The court then invited the parties to submit challenges to any prospective jurors based on their questionnaire responses. The parties thereafter submitted a joint list of 251 prospective jurors they agreed should be stricken for cause. In addition to the agreed upon for cause challenges, the government submitted a list of 34 additional prospective jurors it challenged for cause for various reasons, and the defendant submitted a list of 145 additional prospective jurors he challenged for cause for various reasons. The court then directed the remaining prospective jurors who were not challenged for cause by either party based on their questionnaires to appear for an in-person voir dire. Over the course of 2 days, the court conducted in-person voir dire in 2 phases. During the first phase, the court addressed the prospective jurors in a group setting, advising them of multiple principles of law, including the burden of proof, the defendant's presumption of innocence, and the need to follow the court's instructions. During the second phase, the court spoke with the remaining prospective jurors individually outside the presence of the other prospective jurors, making further inquiries of each prospective juror, including posing additional follow-up questions submitted by the parties in writing and orally during voir dire. During in-person voir dire, the court excluded approximately 34 prospective jurors for cause for various reasons, including scheduling conflicts, English comprehension issues, financial hardship, and concerns about the prospective jurors' impartiality. And then I guess these are the juror numbers that they have listed here. Yeah, I believe these are juror numbers that they released for those reasons. And then it says, after voir dire was complete, the parties exercised their preemptory, I think they spelled this wrong, challenges. And this is basically each side gets so many strikes that they can use. Like if the defense says, oh, I want this person, then the prosecution can use a strike to remove that person, if they have a legitimate reason why they think they shouldn't be serving, and both of them get the same number of strikes. So it says, a pool of qualified prospective jurors and the court subsequently seated and swore 12 jurors and 5 alternate jurors to hear the case. Following the close of evidence and the court's final instructions, the 12 jurors deliberated, ultimately finding the defendant guilty on all 9 counts in the third superseding indictment. With respect to count 1, which charged the defendant with racketeering, the jury found that all racketeering acts, except racketeering acts 3 and 4, had been proven by the government. None of the alternate jurors was called on to deliberate. B. Legal standard. A defendant who attacks his conviction based on claims of ineffective assistance of counsel must 1. Show that counsel's performance fell below an objective standard of reasonableness under prevailing professional norms, and 2. Affirmatively prove prejudice. Demonstrate that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. And that comes from Strickland versus Washington, which was a case heard in 1984. And then Accord Hernandez versus the United States, a case heard in the Second Circuit in 2000. Under the Strickland standard, a petitioner must establish both 1, that counsel made errors so serious that defendant was deprived of reasonably competent representation, and 2, that counsel's deficient performance prejudice the defense. Both prongs must be satisfied to succeed on an effective assistance claim, and the court need not address both components if a defendant fails to establish either one, as a failure on either showing is dispositive. And that came from Strickland. And let's see. Okay, then number 1, deficient performance. With respect to the first prong, a defendant must identify the acts or omissions of counsel that are alleged not to have been the result of reasonable professional judgment. The court must then determine whether, in light of all the circumstances, the identified acts or omissions were outside the wide range of professionally competent assistance. Strickland. Judicial scrutiny of counsel's performance must be highly differential, and strategic choices made after thorough investigation of law and facts relevant to plausible options are virtually unchallengeable. Also see Henry versus Poole, which was heard in the 2nd District in 2005. Actions or omissions by counsel that might be considered sound trial strategy do not constitute ineffective assistance. Internal quotations omitted. Moreover, evaluating counsel's performance must not serve as an opportunity to act as a Monday morning quarterback. United States versus Scali. Citing Strickland, and United States versus Scali was in the Southern District of New York in 2018. Citing Strickland, 466 at 689, Easy versus Sinkowski, which was heard by the 2nd Circuit in 2003, a court must not use perfect hindsight to criticize unsuccessful strategies. And then in Grenier versus Wales, which was heard by the 2nd Circuit in 2005, finding that the performance inquiry examines the reasonableness of counsel's actions under all circumstances, keeping in mind that a fair assessment of attorney performance requires that every effort be made to eliminate the distorting effects of hindsight. Quoting Rompilla versus Beard, which was heard in 2005, rather, a court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that under the circumstances the challenged action might be considered sound strategy. And so basically what they are doing here is just taking quotes from all these cases that have happened in the past. Like, they're not really at this point. I mean, it might get better further down the line, but at this point they are basically just taking quotes from past cases and putting together this response, not actually writing out like how any of this applies to specifics in the case itself. They're just pulling out these quotes. So it goes on, quoting Michael, I think it's Michael, versus Louisiana from 1955. The 2nd Circuit has defined a strategic decision as a conscious, reasonably informed decision made by an attorney with an eye to benefiting his client. Grenier versus Wales, internal citation and quotation marks omitted. When examining an ineffective assistance claim in the context of jury selection consistent with Strickland, an attorney's actions in conducting voir dire are also afforded deference. Ciaprazzi versus Sinkowski from the 2nd Circuit 2005, holding that trial counsel's decision not to seek an alternate juror is paradigmatically strategic. Indeed, courts are loath to second-guess the decisions of counsel during jury selection. Pitek versus Superintendent 2009, and that was in the Western District of New York. Citing Dolio versus Reynolds, which was a case in the Southern District of New York, May of 2002, strategies as to the exercise of preemptories are matters of counsel's intuition and do not rise to the level of constitutional violation. It is not the role of the court to second guess counsel's reasonable strategic decisions at jury selection, especially considering that counsel is strongly presumed to have rendered adequate assistance and made all significant decisions in the exercise of reasonable professional judgment. So then they go on to quote several other cases. An attorney's actions during voir dire are considered to be a matter of trial strategy and cannot form the basis for an ineffective assistance claim unless counsel's tactical decisions are so ill chosen that they permeate the entire trial with obvious unfairness. And I guess we can say that it does permeate the entire trial because the counsel didn't even try. We already had past counsel that was fired, who did nothing, who sat on 3,500 material, who were just egregious in their behavior. And then the lawyers that came in the ninth hour just basically were there embodied, not in professional, like they didn't even try. So I think you can say that they permeated the trial with obvious unfairness because they really didn't even put up a defense and they really didn't care who was selected for the jury. And according to Bonjean, they allowed people to be seated who already had displayed biases and stated that they watched Surviving R. Kelly and they believed what they saw in Surviving R. Kelly. So I think that is pretty egregious. So additionally, if a defendant fails to demonstrate that he requested that his attorney exercise a preemptory challenge for particular jurors, the petitioner is deemed to have acquiesced to the attorney's decision not to do so. So now they're basically saying that if Mr. Kelly didn't tell them to strike somebody, then that meant that he was in agreement. That's like what our parents used to tell us when we were little. Like if you didn't say no, then we assumed you meant yes, right? So that's what they're saying here. So additionally, if a defendant fails to demonstrate that he requested that his attorney exercise a preemptory challenge for particular jurors, the petitioner is deemed to have acquiesced to the attorney's decision not to do so. And that's from Kirkendall Mazuka, and that was in the Western District of New York from 2008. Petitioner has failed to demonstrate he requested trial counsel exercise any challenges as to the jurors, and as such, petitioner is deemed to have acquiesced in trial counsel's decision not to do so. Citing United States versus Reed versus Richmond from the Second Circuit in 1961, holding that defendants' acquiescence of trial counsel's strategic decision amounted to forfeiture of defendants' right to assert constitutional infirmities. And in this case, since we know that Mr. Kelly has a learning disability, did he even know that he was able to challenge? And furthermore, this was an anonymous jury. So how much information did Mr. Kelly actually have? Like, was he sitting in the courtroom when they were doing jury selection? Because the way they were trying to make it seem that they didn't want him to know nothing about these people or who these people were. And then did he have copies of the jury questionnaires to go over to see what these people actually wrote on the jury questionnaire as far as their answers? So I need that information to know, did he see the jury questionnaires? Did counsel go over all 451, however many people they said received the jury questionnaire? Did they actually sit down with him and go through each one of those documents one by one and let him know what these people said on the documents? And we can venture to say that that did not happen because of the time frame was so small between when they did the voir dire and when the actual trial started. So number 2, prejudice. With respect to the second prong, an error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effect on the judgment. So Lindstedt versus Keene, Second Circuit, 2001, quoting Strickland. And when they say quoting Strickland, Strickland was the first case that I mentioned to you guys. And so they're saying that these subsequent cases, that Strickland basically was precedence, and then these subsequent cases relied on the ruling in the Strickland case to make their decision in these cases. Thus, to establish prejudice under Strickland, the defendant must show that there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. So when we look at that, we look at how they brought in all these uncharged bad acts, these bad acts witnesses. So the outcome may not have been different because they stacked the deck so hard against this man with irrelevant information that was dropped on this juror. Like they overwhelmed the juror with all these stories, and then told them that these stories is what made up the racketeering act. So the whole case was filed to begin with. So no, it may not have changed the outcome because you guys had it set up where he was going to fail either way because of the way you worded the instructions to the juror, the way you worded your opening statements, the closing statements, the way you brought in all these expertise who just sat there for hours giving all this technical information that the average person doesn't follow, didn't understand. And so you just overwhelmed the jury with all this babble that they had no choice but to find the man guilty because they couldn't even sit and argue and debate about the information because they probably didn't even understand the information. And like I told you guys in my Cardi B Tasha K video about the t-shirt that I used to have that says, if you can't dazzle them with brilliance, razzle them with bullshit. And basically the Eastern District of New York, I'm sorry guys, but there is a mosquito in my house that is tearing me up right now. So please forgive the stuttering. Okay, I'm getting bit up over here. But anyway, it says, if you can't dazzle them with brilliance, razzle them with bullshit, and the Eastern District of New York razzled that jury with bullshit, okay? And so they wanted to get up out of there. They didn't want to sit there arguing. They just was looking at all this stuff that people were coming in there saying that this man had done. And if you are not into all these different, all these sexual acts, if you're not a fan of 50 Shades of Grey and the bondage and all that stuff, you probably would think that this is all criminal activity and find the man guilty also. So these were people that were sitting there just confused as hell. They had saw the fake documentary. They thought that it was a real documentary that had actually been investigated and proven to be true. And so they just said, okay, he's guilty. He's got to be guilty. If the government has, expended all this time and money and energy to bring in all these experts, and then we got all these people coming in here saying he did this, then he must be guilty. So moving on. They go on to say that a court must review the prejudicial effect of counsel's errors in the aggregate. Moreover, unlike the determination of trial counsel's performance under the first prong of Strickland, the determination of prejudice may be made with the benefit of hindsight, and that was Hemstreet versus Grainer from the Second Circuit in 2007, quoting Mayo versus Henderson, Second Circuit, 1994. To establish prejudice stemming from trial counsel's failure to challenge a prospective juror for cause during voir dire, a defendant must establish actual bias. See Castro versus United States, Eastern District of New York, 2014. However, to maintain a claim of ineffective assistance of counsel based on the failure to object to a biased juror, the petitioner must show that the juror was actually biased against him. Accord Mitchell versus Herbert from 2008, Western District of New York, Therese versus Soberin, And that was a case that was heard in 2001. Based on the lack of actual or presumed bias of the jurors, the petitioner has not demonstrated that he was prejudiced by his counsel's failure to strike these jurors and has therefore failed to establish ineffective assistance of counsel. Then another quote, actual bias is bias in fact, the existence of a state of mind that leads to an inference that the person will not act with entire impartiality. McCarran versus Poole, Western District of New York in 2009, quoting United States versus Torres from the Second Circuit of 1997, actual bias can be found where a prospective juror admits partiality or where the same can be inferred from his or her answers to voir dire questions. Significantly, even where a juror expressly doubts his or her impartiality on voir dire, a finding of actual bias is not automatically mandated. Oh God, Patton versus Yount, which was heard in 1984, holding that ambiguous and contradictory testimony of 3 jurors was insufficient to overcome presumption of correctness owed to trial court's findings that the jurors would be impartial. The test for determining juror bias is well established. To hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebut the presumption of a prospective juror's impartiality would be to establish an impossible standard. It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Okay, so they're saying that basically ain't no way you can throw out a case because of juror impartiality. So then they go on, and I mean, like, they are just they're not really giving an opinion here. Everything that I have read to you all so far is just case law. They're just taking quotes from other cases and putting together this motion. They are not giving an opinion themselves so far. So Diaz versus Conway, Southern District of New York, 2008, quoting Irvin versus Dowd from a 1961 case, even where a juror previously expressed some reservations about his ability to be fair and impartial, if the juror later expresses during voir dire that he will try to decide the case based on the evidence presented, that assurance is generally sufficient. United States versus Town, Second District, Second Circuit, 1989. Therefore, to prevail on a claim that defense counsel was ineffective in failing to remove or challenge a juror during voir dire, a defendant must show that the juror was actually biased against him. Well, we know they were biased because they stated in the questionnaire that they watched the documentary and they believed the documentary. He wasn't in the documentary. His voice wasn't a part of the documentary. He didn't give his side of the story in the documentary. So if you believe that the documentary was true, then you walked into the courtroom with a bias against him. So then it goes on to say, without a finding that the juror was actually biased against petitioner, prejudice under Strickland is not presumed. And then they give an analysis. It says the defendant's ineffective assistance claims are wholly without merit. He cannot establish either prong under Strickland and his motion should be denied. The defendant, and then they're assuming that Strickland is the only case. I'm sure that Bonjean can come back with other cases where the courts ruled that the jury was biased and therefore overturned the case. So keep in mind that this is just cases that the prosecution has found to support their cause. So it says the defendant first makes one generalized assertion that trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice. And 2, unfounded and vague claims that trial counsel should have for example, probed more deeply, inquired further, or completely questioned certain jurors. These claims are wholly belied by the record, which shows that trial counsel actively participated throughout the voir dire process, submitting additional questions and asserting challenges for cause, both in writing and orally, in some cases successfully, as to various prospective jurors, including those prospective jurors whose impartiality may have been in question, in addition to the defendant's written for cause challenges with respect to the approximately 50 prospective jurors initially qualified after the first 2 days of in-person voir dire. The defendant requested that the court make further inquiries of approximately 19 prospective jurors, including additional questions related to prospective jurors' opinions on the Me Too movement and related topics, as well as their knowledge of the defendant and the nature of the charges. And then I guess these are the juror numbers that they have listed here. On various occasions, after hearing certain prospective jurors' responses to the follow-up questions, trial counsel did not challenge them. However, with respect to certain other prospective jurors, for example, prospective jurors numbers 120 and 182, defense counsel challenged, and the court ultimately excused the prospective jurors for cause based on the responses to inquiries related to the Me Too movement. Trial counsel's inquiries on those topics clearly reflect that they considered the very issues now raised by the defendant when making for cause and preemptory challenges, and made strategic decisions in certain instances not to challenge a particular prospective juror based on their responses to inquiries from the court and the parties. Guerrero versus Payant, which was in the Eastern District of New York in 2010, reasoning that the fact that trial counsel's decisions not to challenge a juror for cause was strategic may be evidenced by trial counsel's use of for cause challenges on their prospective jurors. Figueroa versus Heath, which was heard in the Eastern District of New York in 2011, finding that counsel's active participation in voir dire indicates that any decisions to challenge or not to challenge jurors were made as part of a reasonable trial strategy, rather than as a result of counsel's failure to provide effective assistance. Warwick versus McLaughlin, Southern District of New York in 2004, rejecting ineffective assistance of counsel claim regarding voir dire because the record reflected that defense counsel was actively engaged in the voir dire process and attorney's determination to accept or strike a prospective juror was a strategic or tactical decision. Rodriguez versus Breslin, Eastern District of New York, 2009, finding that counsel's decision to preemptorily challenge 8 jurors lent support to conclusion that decision not to challenge allegedly biased jury was part of trial strategy. Nova versus Eckrol, Southern District of New York, 2007. Counsel exercised two Lord, I've been pronouncing the word wrong, or they have it spelled wrong. Peremptory challenges for other prospective jurors during voir dire. This suggests that counsel deliberately chose not to challenge another juror as part of trial strategy that might be considered sound. Internal quotation marks and citations omitted. So, let's see. They go on. Nor was the defendant shown that he suffered any prejudice. He provides no tangible evidence of actual bias, relying only on speculation based on the challenged jurors' responses during voir dire as purported evidence of bias. See example Diaz from Southern District of New York, 2008, finding jurors were not actually biased against petitioner and therefore he was not prejudiced by trial counsel's failure to challenge them, where petitioner offered no evidence beyond the voir dire testimony of three individuals as to how the jurors were biased, other than speculation regarding these jurors' ability to be impartial, given that each of the jurors at issue asserted their impartiality and that they could fairly decide the case. Indeed, the very fact that the defendant asserts that trial counsel should have uncovered some additional imagined information, but produces no actual information supporting the claimed bias, emphasizes the speculative nature of these claims. In addition, the defendant's claims regarding trial counsel's failure to challenge prospective jurors who, one, had some knowledge of the defendant and or the allegations against him, including through affirmative responses to question 31, indicating they had watched or heard interviews of Robert Kelly, TV shows featuring him, or specials of documentaries about him, or two, knew of the Me Too movement, also lack merit. As the Supreme Court has made clear, qualified jurors need not be totally ignorant of the facts and issues involved in a case. Murphy versus Florida, a case from 1975. See also Reynolds versus United States. Every case of public interest is almost as a matter of necessity brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has not some impression or some opinion in respect to its merits. United States versus Ayala State, then that was in the Eastern District of New York, 2014, stating that in most cases, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. Internal citations omitted. Beard versus Unger, which was in the Western District of New York in 2009, rejecting ineffective assistance claim, finding that defense counsel's decision not to challenge a juror was within the realm of sound trial strategy, and that defendant could not establish actual bias where police officer juror advised he could have had personal knowledge of the facts of the case in his employment but did not recall any such knowledge and could remain impartial. Further, the defendant's unsupported assertion that the jurors' own subjective assurances that they could be fair was not sufficient to ensure that they did not harbor beliefs or preconceived ideas about defendant's guilt flies in the face of both the record and binding legal precedent that it is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Quoting Irvin, that was a federal case. Okay, as set forth in further detail below, the defendant has abjectly failed to prove that trial counsel did not act strategically in deciding not to challenge certain jurors for cause or use peremptory strikes to prevent their selection. He also fails to show that any of these jurors bore actual bias against the defendant. He therefore cannot show deficient performance or prejudice. Okay, so let's stop here for a minute, because remember, this was an anonymous jury. Nobody has heard from these jurors since that trial ended. Nobody saw these jurors. We don't know who these jurors are. They didn't get to research these jurors, because usually during jury selection, you can get the names of the jurors and you have investigators that do social media forensics, and they find these people's social media accounts. They find different information basically online, anything that they can pull on these people to determine their biases. They were not, R. Kelly's team was not afforded that opportunity because it was a quote-unquote anonymous jury. In addition, investigators can go into the community and they can talk to their neighbors, they can talk to their co-workers, they can talk to people that know the jurors and get a sense of how these people feel about the case. But because it was anonymous juror, they didn't have the opportunity to do that. So when they talk about the attorneys being strategic, there was no strategy. They were dealing with the hand that they had been dealt. And I guess they just they got rid of the worst of the bad apples, right? But there were still bad apples in the bunch. They just got rid of the worst ones, if that makes sense to you guys. So we're going to move on. So 1, juror number 3, formerly prospective juror number 25. The defendant asserts that trial counsel was ineffective in failing to challenge juror number 3, given his responses that he had seen a documentary about the defendant and his legal troubles, and heard that he has been sleeping with underage girls. Now, these are quotes from what the juror wrote on their questionnaire. As noted above, the mere fact that a juror has knowledge regarding the defendant or aspects of the charges does not automatically create a presumption of bias, particularly where, as here, the juror has indicated that he can set aside his prior knowledge and decide the case based solely on the evidence presented at trial. Okay, then let's talk about the tainted evidence that was presented at trial. Okay, so indeed, the defendant completely ignores, as he does with each juror's affirmation of impartiality, juror number 3's unequivocal statements, both in response to the questionnaire and during in-person voir dire, which reflect a total lack of bias and a clear ability to be impartial. For example, in response to question 31, juror number 3 advised that he had seen a documentary about the defendant, but added, "I don't know the full story, so I have no feelings about it. I remain impartial." Question 31, emphasis added. Moreover, in response to question 32, which asks whether he had an impression of the defendant based on what he had seen or heard, juror number 3 advised that his impression was neutral, adding that the media tends to demonize people. I deal with facts. Question 32. Juror number 3 also advised that he had not overheard discussion about the case, nor had he discussed the case with anyone or online. See questions 33, 34, 35. Juror number 3 further responded that neither the defendant's celebrity nor anything about the nature of the case would interfere with his ability to decide the case fairly and impartially in accordance with the court's instructions. With respect to questions regarding the so-called Me Too movement, juror number 3 indicated that he was aware that the movement seeks justice for rape victims 25 to 30 years after the fact, and also stated that he had not participated in the Me Too movement. Juror number 3 also indicated he had no reason to believe he could not apply the law that the defendant is innocent until proven guilty, and the government bears the burden of proof. During in-person voir dire, juror number 3 further affirmed his ability to be fair and impartial. When asked whether there was any reason he could not follow the court's instructions regarding the burden of proof and the fact that the defendant was innocent until proven guilty, juror number 3 responded, "No reason at all." When asked by the court whether there was any reason why he would not be able to follow the court's instructions on the law, juror number 3 responded, "No, I'm a stickler for the law on my job. I'm the rule guy." Moreover, juror number 3 answered that there's no reason at all why he could not follow the court's instruction not to research the facts, law, or people involved in the case, and when asked by the court, "Is there any reason at all why you wouldn't be able to give both sides a fair trial?" juror number 3 again unequivocally answered no. In these circumstances, the defendant cannot show deficient performance in counsel's decision not to challenge juror number 3, and also fails to prove any actual bias on juror number 3's part that would result in prejudice, failing both Strickland prongs. Indeed, it was clearly sound strategy on the part of trial counsel to not exercise a preemptory, see, I think they were spelling it when they were saying preemptory challenge. Juror number 3 explained in his questionnaire that he had been arrested on 2 occasions, which resulted in charges being dismissed. And during the colloquy with the court, emphatically expressed that he had previously had certain negative experiences with law enforcement, and that while he was not biased against law enforcement, he was biased against people in law enforcement that do these things. Thus, trial counsel likely, made the strategic decision to keep juror number 3 because they believed the juror's past negative experiences with law enforcement, including being falsely arrested twice, coupled with his belief that the media demonizes people, would make him more critical of the government's case. Trial counsel may also have reasonably believed that the government might use a preemptory strike on juror number 3, given the government's follow-up questions, which trial counsel may have interpreted as concern regarding juror number 3 on the part of the government. Then they cite a case, Ely versus Urkel, from the Eastern District of New York, May 6, 2010, rejecting claim of ineffective assistance of counsel where defense counsel did not object during voir dire process because, among other things, counsel, among other reasons, failed to object so as to force the prosecution to expand an additional preemptory challenge to strike the juror. 2. Juror number 4, formerly prospective juror number 52. The defendant next claims deficient performance due to trial counsel's failure to challenge juror number 4 based on the juror's questionnaire that the juror finds transmission of STDs in a non-consensual act to be particularly repulsive, has a close friend who was a victim of sexual assault, and listed the person he least admired as Jeffrey Epstein. Again, the defendant fails to carry his burden to establish either Strickland prong. Juror number 4's questionnaire and voir dire responses in no way amount to actual bias against the defendant. A juror is not required to have entirely neutral feelings about the particular types of crimes charged. Figueroa from 2011, denying post-conviction relief and finding trial counsel's decision not to challenge prospective juror in narcotics trial who expressed views about dangers of drug use given family history of drug abuse was not deficient performance where juror affirmed ability to be fair and impartial after court advised juror that nobody is asking you to walk in here totally blank. You will bring in your life experiences, and that the relevant question was only whether juror could follow the law as I give it to you, and will you be fair and impartial. Rather, the central issue is whether the juror can lay aside any preconceived notions. See Town. Here, juror number 4 indicated that he could. So I'm going to stop right here for a second in the middle of juror number 4. So basically, if you're called for jury duty and you've heard about the charges and allegations against the defendant, in this case, Mr. Kelly, and you want him to pay, and remember, we have had report after report after report about people wanting him to pay. Like this verdict that was reached was supposed to be to reconcile the not guilty verdict that happened in 2008. So if you're called to jury duty to sit on the case of somebody that you thought should have been found guilty in 2008, and you want to make sure he's held accountable this time, that you're vindicating that verdict from 2008, wouldn't you sit there and say, I'm impartial, I will be fair, I will hear both sides of the story? Like, how easy is it for people to sit there and lie if they want to be a part of this historic case where they're finally bringing this R&B singer who has this bad reputation to justice? So where is the line drawn in determining whether somebody is biased and have alternative motives for joining a jury? Like, how do you get to the bottom of that? How do you pull out that bias? And we don't know who these jurors are because not one of them has came forward to give an interview. We don't even know the friends. We haven't seen any relatives of these jurors say, I know the person that was on that jury. We haven't seen any friends, co-workers, nobody. Like, we don't know who this jury is. And I bet you, if we start getting some names of these jurors, we will start learning about some biases. We will be getting some comments that person made against R. Kelly. All of that will start coming out if we are able to identify who these jurors were. So moving on, nor was bias established on the ground that juror number 4 knew an individual who was a victim of sexual assault, notwithstanding that the charges against the defendant involved assault. United States versus Udogwu, okay, sounds African. Southern District of New York, June 9th, 2003, finding that bias could not be inferred, where juror advised the court that, among other things, his wife had been abused before they were married in case involving prosecution of defendant for forced labor of 2 young girls. Importantly, in response to question number 37, which asks whether there was anything about the nature of the charges in and of themselves that would prevent the juror from deciding the case fairly and impartially in accordance with the court's instructions, juror number 4 responded no. Likewise, in response to question 65, which asked if there was any reason why juror number 4 could not apply the law that the government bears the burden of proving the defendant guilty beyond a reasonable doubt on each charge, juror number 4 responded no. In fact, as was evident from juror number 4's questionnaire and in person voir dire, juror number 4 had very little knowledge of who the defendant was, confusing the defendant's alias R. Kelly with a famous cartoonist from decades earlier. Even upon clarification that the defendant was not the cartoonist, juror number 4 had very little knowledge of the defendant and had seen some news articles that did not appear to have made any impression on him. When asked whether there was anything that juror number 4 had read that would affect his ability to be fair and impartial in the case, he responded, "Not that I know of." Moreover, when the court spoke of the duty of jurors to decide the case based on the evidence at trial, juror number 4 added that the case was to be decided by the evidence, testimony, and your instructions on the law, clearly demonstrating his understanding of his duty as a juror. When the court advised juror number 4 that the government bore the burden of proving the defendant guilty beyond a reasonable doubt, juror number 4 responded right and stated that he would have no problem following the court's instruction that the defendant is innocent until proven guilty. And I am quite sure that when they got them instructions, they didn't know what the hell y'all was talking about, okay? Because y'all worded that questionnaire and those instructions in a way that these people had no other choice unless there was a lawyer in there explaining it to them. They felt that they had no other choice but to find him guilty based on how those instructions were worded. Therefore, any potential concerns that may have arisen from juror number 4's questionnaire responses were alleviated by juror number 4's clear responses in the questionnaire and during voir dire that he could remain fair and impartial and decide the case according to the court's instructions. In these circumstances, the defendant cannot show either deficient performance, or actual bias, and his claim should be rejected. 3. Juror number 5, formerly prospective juror 87. The defendant claims that trial counsel should have challenged juror number 5 because she had some knowledge of the defendant and had a somewhat negative impression of him. In response to why juror number 5 had this impression, juror number 5 wrote that there was an allegation that related he was sleeping with underage girls or minors. Question 32. Notably, juror number 5 specifically used the word allegation to describe whatever knowledge she may have had about the case. Despite being aware of this allegation, which is no more than was included in the summary of the case provided as part of the juror questionnaire, juror number 5 advised that she had not overheard any discussion about the case, discussed the case with anyone, or posted any opinions online. Okay, before I continue, let me read this note at the bottom of the page. It says the defendant also cannot show the decision not to challenge juror number 4 was not strategic, as juror number 4 indicated he had negative interactions with law enforcement, question 61, and his close friend was infected with HIV by police in a foreign country, question 55. Okay. So juror number 5 further responded that neither the defendant's celebrity nor anything about the nature of the case would interfere with her ability to decide the case fairly and impartially in accordance with the court's instructions. During the in-person colloquy, the court asked juror number 5 whether, despite having some familiarity with the case, juror number 5 was able to put aside anything that juror number 5 had heard about the case and just judge it on the evidence that you hear in the courtroom. Juror number 5 responded yes. The court asked a second time, stating okay, and put aside all those other things you might have heard, to which juror number 5 again stated yes. Shortly thereafter, the court asked juror number 5 whether there was any reason she could not follow the court's instruction that the defendant was innocent until proven guilty, and that the government has the burden of proving the defendant guilty beyond a reasonable doubt. Juror number 5 again responded no. In response to the court's inquiry as to whether the juror was hesitating a bit in her answer, juror number 5 stated, no, there wouldn't be no reason that I wouldn't be able to. Where I work, we have to follow the order. In response to the court's further questions regarding whether juror number 5 would follow the important principle of law regarding the burden of proof and would follow the court's instructions on the law, juror number 5 said yes to both. During this portion of the questioning, juror number 5 initially responded, well, as you mentioned, according to when you listen, whatever you hear, so I think I'll give it a shot. Okay. Well, girl, you heard a bunch of nonsense, okay, and I guess you couldn't sort it out in your brain. As a result, a colloquy followed in which the court explained to juror number 5 that regardless of her answer, juror number 5 needed to be positive in that response. When asked if she was positive that she could give both sides a fair trial, juror number 5 said yes, that she could be positive in her belief that she would be fair and impartial. Importantly, juror number 5's use of the word think in her response to the court's questions does not demonstrate implied or actual bias. And then they quote Diaz at finding no bias. One juror replied, no, I don't think so, after being asked whether she might favor the prosecution's argument, their evidence, their witnesses, because you are a member of their office, and confirmed that she would acquit the defendant if she found the prosecution had not proved this case. And then in another case, Beard, which was heard in 2009, finding juror had no actual or implied bias warranting relief, where when asked whether his experience as a police officer would carry over into petitioner's trial, the juror responded, well, sir, I would certainly like to be able to say that it wouldn't, and I would certainly do my best to see that it did not. Moreover, even if juror number 5's response demonstrated some initial ambiguity about her impartiality, she affirmatively stated that she could be fair and impartial upon further questioning. Trial counsel's decision, therefore, not to challenge her was not deficient. And then they go to another case, Guerrero from 2010, rejecting claim of ineffective assistance of counsel based on trial counsel's decision not to make a for-cause challenge where juror expressed doubts about his ability to be fair and impartial given his employment as a police officer, but subsequently answered in the affirmative upon further questioning about whether he could base his decisions in the case solely on what he would see and hear in the courtroom, and where there was no evidence in record that the court would have granted a challenge for cause, even if defense counsel objected. Then in Rodriguez versus Breslin, which was heard in the Eastern District of New York in 2009, holding that the decision not to challenge a juror for cause when that juror expressed that she was sensitive to the issue but ultimately stated that she would try to remain fair and impartial did not amount to ineffective assistance of counsel, particularly where based on the juror's response to a hypothetical question posed during voir dire. The attorney may have reasonably inferred that the juror would be sympathetic to the defense strategy he planned to use at trial. Then in Wallace versus Artis, Northern District of New York, March 31st, 2011, finding no actual bias where juror initially stated that he could try to be fair and impartial and then subsequently agreed that he would leave sympathy and emotions out of his deliberations and decided from the facts on the witness stand. Also see Town, concluding that district court did not err in failing to remove prospective juror for cause where juror initially expressed reservations about ability to be impartial but later promised to try to decide the case based on the evidence presented. Then United States versus Plouffe from the Second Circuit in 1972, upholding the denial of challenge for cause where a juror indicated he would do his best to decide the case based on the evidence presented. The defendant thus cannot show deficient performance or actual bias and fails both Strickland prongs. And then also let me add in here, I'm surprised that Jennifer Bongine did not raise the whole anonymous jury selection. Like, I think that would have been an interesting argument to present, that they were allowed to do this anonymous jury thing. But then again, there's been several high-profile cases where they use anonymous jurors, so maybe that's not a good argument. So number 4, juror number 7, formerly prospective juror number 145. The defendant asserts that trial counsel was deficient in failing to challenge juror number 7 because she had heard certain information about the defendant's alleged crimes. The claim is baseless. While juror number 7 advised that she was aware of who the defendant was and the existence of a case against him, juror number 7 stated that she had not seen any documentary about the defendant and that her impression of the defendant was neutral because most of the information you hear about celebrities are not always true. It's mainly either for or against the person. Juror number 7 also advised that she had not discussed the case with anyone or posted any opinions about defendant online, and made clear that she would remain fair and impartial in deciding the case, indicating that there was no reason she would not follow the court's instructions regarding the burden of proof and the fact that the defendant is innocent until proven guilty. During the in-person voir dire, when asked whether she could put aside the very little she had heard about the case and rely only on the evidence in court, juror number 7 answered sure. Moreover, when asked if she promised that she will be a fair and impartial juror to both sides, juror number 7 responded, of course. In these circumstances, the defendant cannot show actual bias and his ineffective assistance claim must fail. In addition, the defendant cannot show that trial counsel's decision not to strike juror number 7 was not strategic. During trial, defense counsel sought to emphasize the defendant's musical talents and popularity as part of his trial strategy. Thus, trial counsel may have believed that juror number 7's knowledge of the defendant's music and her lack of knowledge of the Me Too movement made juror number 7 an attractive juror. In any event, in light of the juror's unequivocal responses establishing her impartiality, the defendant cannot show actual bias or that the court would have granted a motion to strike. 5. Juror number 8, formerly prospective juror number 147. The defendant claims that trial counsel was deficient in failing to challenge juror number 8 because he had heard about the crimes that the defendant allegedly committed. Notwithstanding such knowledge, juror number 8 advised that he had a neutral impression of the defendant and that he had no feeling toward the defendant. Question 32. In response to other questions, let me pause this for a second, guys. Okay, I'm back. I left off with juror number 8. The defendant claims that trial counsel was deficient in failing to challenge juror number 8 because he had heard about the crimes that the defendant allegedly committed. Notwithstanding such knowledge, juror number 8 advised that he had a neutral impression of the defendant and that he had no feeling toward the defendant. In response to other questions, juror number 8 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, juror number 8 also answered each of the court's questions in unequivocal manner, consistent with his ability to put aside anything he knew about the case, hold the government to its burden to prove the defendant guilty beyond a reasonable doubt, and judge it fairly and impartially. In these circumstances, the defendant cannot show actual bias, nor can the defendant show that trial counsel did not strike juror number 8 for strategic reasons. In the questionnaire, juror number 8 advised that he listens to the defendant's music and has no views of the case. Given juror number 8's other responses indicating that he had no knowledge of the Me Too movement and could clearly be fair and impartial, trial counsel likely believed that juror number 8 was a fan of the defendant's music and thus would be a favorable juror for the defense. In any event, in light of the juror's unequivocal responses establishing his impartiality, the defendant cannot show actual bias or that the court would have granted a motion to strike. Juror number 9, formerly prospective juror number 156. The defendant claims that trial counsel was deficient in failing to challenge juror number 9 because she had heard that the defendant had unknown issues with the law and had knowledge of the Me Too movement. In response to questions regarding whether juror number 9 was familiar with the defendant or any allegations against him, juror number 9 wrote, "Sounds familiar but unsure," and that the defendant had issues with the law before but couldn't tell you exactly for what. Juror number 9 also indicated that she had a neutral impression of the defendant because I know he's been arrested before, but don't know if he was convicted or not. I don't watch entertainment news or follow gossip influencer sites about celebrities. In response to a question concerning knowledge about the Me Too movement, juror number 9 described the movement as the power structure of the male-dominated movie industry has been turned on its head, and indicated that she had not participated in the Me Too movement. In response to other questions in the questionnaire, juror number 9 made clear that she would judge the facts of the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, the court asked juror number 9 whether she could put aside any prior knowledge that she may have had about the case and decided only on the evidence presented in court. To which juror number 9 responded, "Yes, I can." In response to questions regarding whether juror number 9 promised to follow the court's instructions on the burden of proof, the defendant's presumption of innocence, the law, and refraining from obtaining outside information about the case, juror number 9, as she did in the questionnaire, answered in the affirmative to all, promising to do her duty as a fair and impartial juror. Let me stick a pin here. If the people didn't answer in the affirmative to all of these questions, they would not have been on the jury, right? So this really means nothing that they answered in the affirmative, because in order to be picked for the jury, you have to say that you will be fair and impartial and listen to the evidence. Because if you sit there and say, "No, I can't," then you're not going to be chosen. And then, if I'm recalling correctly, they didn't even go through all of the prospective jurors. So after they had eliminated so many people and gotten down to, I think it was 50, they didn't go through all 50 people. They picked the 12 jurors and the 5 alternates before they went through the 50 people. So there were still like 20 people left who didn't even get to the stage of affirming that they would be fair and impartial. Who were those other people? And once again, they're saying that they had almost 500 people that were sent questionnaires. I can't remember the exact number. It might have been 455 or something like that. Then they narrowed it down. Then they narrowed it down to this 50. Who are these 50 people? And I'm going to keep saying that to the end of this video. Who were the 50 people? Why have we not heard from these people? Why don't we know anybody who know any of these people? Why is there such silence and secrecy? And the same thing, I think only like a couple of people have come out in the Maxwell case also. But the couple who did showed that they were biased, even though they said that they would not be biased. They've proven that they were. Anyway, let me continue on with this juror number 9. So the defendant has offered no evidence to suggest that trial counsel's decision not to strike juror number 9 was anything but strategic. As an individual who had a neutral view of the defendant, did not follow gossip sites about celebrities, and who had a relative who was convicted of a federal crime and served 5 years in prison, trial counsel likely believed that juror number 9 would be favorable juror for the defense. And just let me say, having known somebody who has served time in prison has no bearing whatsoever on whether or not you can be fair and impartial in a case. So I'm not sure why it even matters. Like, why is that even a question? But every jury questionnaire that I have ever received, they do ask if you know somebody who's been convicted of a crime. But in most cases, it'll be like if the case is about a robbery suspect, they'll ask you, do you know somebody who's been arrested or convicted of a crime related to robbery or theft? It's not like a general question. And even if you say yes, like, what does that have to do? Like, did your relative commit the crime or not? Like, what does that have to do with the person that's on trial, or that they are getting ready to pick a jury for on trial? So, just my personal opinion about that question. So, trial counsel likely believed that juror number 9 would be a favorable juror for the defense. In these circumstances, the defendant cannot show actual bias or deficient performance, and his ineffective assistance claim fails. In any event, in light of the juror's unequivocal responses establishing her impartiality, the defendant cannot show that the court would have granted a motion to strike. Okay, so I guess when they're saying that they wouldn't have granted a motion to strike, they're saying that if the defense had raised an issue with these people, it wouldn't have mattered, because the court that Donnelly would not have stricken them anyway, that they still would have been seated on the jury. So number 7, juror number 11, formerly prospective juror number 153. The defendant claims that trial counsel was deficient in failing to challenge juror number 11 because she had heard and read about the alleged crimes in the news. Specifically, in response to questions regarding whether juror number 9 was familiar with the defendant or any allegations against him, juror number 9 wrote that she saw the case mentioned on the news when the defendant was first being investigated, knew that the defendant is a musician, and that there were allegations of misconduct lodged against him. Juror number 11 also indicated that she had a neutral impression of the defendant because I do not know enough information about the defendant or the case. In response to other questions in the questionnaire, juror number 11 made clear that she would judge the facts of the case fairly and impartially in accordance with the court's instructions. And then also, I don't know if I mentioned this earlier, when they're giving these responses, they're actually citing the question that was on the questionnaire, and I'm just not reading that for the sake of trying to get through this quickly. Similarly, during in-person voir dire, when asked by the court whether she could put aside any prior knowledge that she may have had about the case and decided only on the evidence presented in court, juror number 11 responded yes. In response to questions regarding whether juror number 11 promised to follow the court's instructions on burden of proof, the defendant's presumption of innocence, the law, and refraining from obtaining outside information about the case, juror number 11 answered in the affirmative to all, promising to do her duty as a fair and impartial juror. In these circumstances, the defendant cannot show actual bias or deficient performance. Number 8, juror number 12. Lord, can we get through these jurors and move on to something else? The defendant claims that trial counsel was deficient in failing to challenge juror number 12 because he had heard about the crimes that the defendant allegedly committed from various sources and had knowledge of the Me Too movement. While juror number 12 indicated that his somewhat negative impression of the defendant was a result of an emotional response to the nature of the charges against the defendant, juror number 12 also advised in that same response that he really never cared one way or the other regarding the defendant. In response to other questions in the questionnaire, juror number 12 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. During in-person voir dire, when the court raised the fact that juror number 12 had indicated on the questionnaire that he had some information about the case, juror number 12 advised the court that it was just minor things in the press. Nothing, I can't recall any specific details. Juror number 12 added that, in fact, the summary and questions included in the questionnaire provided more information about the nature of the case than what he had previously been aware of through any media coverage. When asked whether he could put that information aside and judge the case based on the evidence presented in court, juror number 12 responded, of course, stating, it most definitely is. When the court referenced juror number 12's statement in his questionnaire that trial by media is worse than trial by jury, subsequently, in response to questions by the court regarding whether juror number 11 promised to follow the court's instructions on the burden of proof and the defendant's presumption of innocence, juror number 11 responded 100%. Further, with respect to the court's inquiries about whether he could follow the law as the court instructed and refrain from obtaining outside information about the case, juror number 11 answered, child, I thought we was on juror number 12. What is they talking about? Okay, I don't know what juror they talking about because they keep going back and forth between juror number 11 and juror number 12. Okay, answered in the affirmative, promising to do his duty as a fair and impartial juror. The record thus clearly reflects that there was no actual bias on the part of juror number 12. Okay, I think they're talking about juror number 12, but they keep saying juror number 11. Trial counsel's conduct with respect to this juror was also not deficient under Strickland. First, counsel had a strategic reason not to strike this juror. In the questionnaire, juror number 12 advised that he had a friend who was related to Bill Cosby and as part of his discussion of his opinion of Bill Cosby's assault case, both in the questionnaire and during voir dire, indicated that until the end of the case, I have no opinion, adding that trial by media is scarier to me than a jury. Juror number 12's position regarding Bill Cosby's case not only reflected his ability to keep an open mind unless and until he had all the facts, but also likely formed the basis of trial counsel's strategic decision not to strike juror number 12, given the nature of Bill Cosby allegations. In addition, juror number 12 had a family member who was sentenced to 10 years in prison. A reasonable attorney could certainly have believed that juror number 12 would be a favorable juror for the defense, notwithstanding his somewhat negative view of the defendant or knowledge of the Me Too movement for this reason. In any event, in light of the juror's unequivocal responses establishing his impartiality, any for-cause challenge would have been futile. 9. Alternate juror number 4, formerly prospective juror 179. Finally, the defendant claims that trial counsel was deficient for not challenging alternate juror number 4 as a result of her knowledge that the defendant was married to Aaliyah, and as he characterizes it, for making an untimely challenge to alternate juror number 4 during trial for asking the court's clerk whether the clerk had obtained an autograph from attorney Gloria Allred, who represented certain of the witnesses at trial on her behalf. Even assuming arguendo, that alternate, I don't know what that is, arguendo, assuming the argument maybe, that alternate juror number 4 should have been dismissed notwithstanding the court's proper determination on the matter, given that this alternate juror did not deliberate and thereby had no impact on the verdict. The defendant cannot show prejudice from her selection as an alternate. See Town, and then in that case it says, more important, however, appellate cannot demonstrate that he was prejudiced by the trial judge's refusal to excuse this person for cause, since prospective juror was never a member of the juror that convicted the defendant. Moreover, as the defendant concedes, trial counsel did in fact seek alternate juror number 4's dismissal. As such, the defendant cannot show that trial counsel engaged in deficient performance under Strickland. Okay, so they tried to get the person removed, but the judge said no. Okay. Finally, as reflected in the record and set forth in great detail in the government response to the defendant's motion for a judgment of acquittal, which is incorporated herein by reference, the evidence against the defendant on all charges was overwhelming, and the defendant has presented no evidence to demonstrate that the jury's verdict was based on anything other than the evidence presented at trial. Oh, child. Let's see. Then they got a bunch of notes. The defendants claim that trial counsel's motion to exclude the juror was untimely is baseless, while alternate juror number 4 had left the courtroom at the time of the challenge, and therefore it was made outside alternate juror number 4's presence, which is entirely customary. Trial counsel made the motion immediately following the colloquy on the matter. 7. Notably, the defendants claim that trial counsel should have pursued alternate juror number 4's dismissal during voir dire. Likewise, failed Strickland, given the trial counsel's performance was not deficient and there was no prejudice, while alternate juror number 4 referenced some knowledge of the defendant and possible rumors of her marriage to Aaliyah. She advised that she was able to put any such knowledge aside and decide the case fairly and impartially during voir dire. However, trial counsel requested that the court inquire further regarding alternate juror number 4's stated history and experience with sexual harassment, and indicated that he was going to challenge her. However, upon hearing her answers to the court's additional questions on this topic, trial counsel made the strategic decision not to challenge this juror. And then note number 8, importantly, while the jury found the defendant guilty on all counts, they found that racketeering acts 3 and 4 of count 1 had not been proven by the government, emphasizing that the jurors carefully reviewed the evidence in the case, honored their oath to find a racketeering act or count proven only if they believed the government had met its burden of proof and were not clouded by the purported bias that the defendant now baselessly claims permeated the jury. Okay, so then it picks back up and says assistants of counsel claimed that trial counsel's failure to strike juror who was allegedly equivocal as to whether she could hold the prosecution to its burden and allegedly evince a quote unquote state of mind likely to preclude her from rendering an impartial verdict. Like merit, finding that in the absence of bias, petitioner cannot satisfy the second prong of Strickland because there is no basis to conclude that, had the juror not been seated as a juror, the result of petitioner's trial would have been different. Okay. Accordingly, the defendant claims that trial counsel provided ineffective assistance of counsel during voir dire should be denied. Okay, part 3. The defendant was not denied conflict-free counsel. A. Relevant background. Pursuant to its obligations under United States versus Curcio, the government brought certain issues to the attention of the court regarding potential conflicts held by one of the defendant's retained attorneys, Nicole Blank-Becker. The potential conflicts raised by the government were set forth in detail in sealed written submissions dated June 14, 2021. The sealed June 14, 2021 letter and June 24, 2021 the sealed letter, collectively referred to herein as the sealed letters and incorporated herein by reference. The defendant bases his motion on one of these issues, specifically regarding the possibility that Ms. Blank-Becker entered into an attorney-client relationship with certain individuals, including an individual referred to in the sealed letters as Jane Doe number 5 and herein as Jane, who we already know is Ariel Clary. Another issue also relevant to the instant motion related to the individual identified at trial as Joy or Jocelyn and is detailed in the sealed letters. And then there is a note that says, though incorporated herein, the sealed letters should remain under seal for the reasons set forth in the sealed letters. Okay, well, we want to know what the sealed letters are. Somebody need to file a lawsuit to get the letters unsealed so we know what was in the letter. So following the government's filing of its Curcio letter, the court appointed independent counsel to advise the defendant on the issues, and on June 17, 2021, the court conducted a Curcio hearing, which was further adjourned to allow the defendant ample time to confer with independent counsel. On July 15, 2021, the court continued the Curcio hearing to determine whether conflicts existed and whether the conflicts were waivable by the defendant. In making its determination, the court relied upon written submissions and exhibits by the government. Ms. Blank-Becker and Ms. Gloria Schmidt-Rodriguez, who formerly represented Ariel, as well as proffers of information by the government, Ms. Blank-Becker and Ms. Gloria Schmidt-Rodriguez. Based on this information, the court determined that potential or actual conflicts existed with respect to the issues raised by the government, but that all of the raised conflicts, including those related to Ariel, could be waived by the defendant. Based on its findings, the court advised the defendant of each of the conflicts and the relevant implications of those conflicts. During the hearing, the court also advised the defendant that he had the right to conflict-free representation, but under the circumstances could waive the conflicts if he so chose. Relevant to the instant motion, the court advised, among other things, that Miss Blank Becker may have developed a relationship of trust with certain individuals, including Ariel and Jocelyn, even though she were never formally retained as their lawyer. She has confidentiality obligations to them, and given the nature and extent of those communications and the content of them, she would have a conflict if she were to cross-examine either one of them. So that's one of the conflicts. And then let me go back up here and read this note. And it's just basically saying references to the July 15, 2021 Curcio hearing transcript are cited as Curcio. Okay. So the court also advised the defendant that Ms. Blank Becker could not rely on or share with the defendant or his other attorneys any privileged information she may have obtained from these individuals. Also relevant to the instant motion, the court advised the defendant of the implications of a possible conflict related to an allegation regarding Jocelyn set forth in the sealed June 14, 2021 letter at pages 1 through 2, noting that there was not much of a foundation for the allegation. While the court did not make a specific finding as to whether Ms. Blank Becker had committed an ethical violation by contacting Ariel while she was represented by Ms. Rodriguez, the court also advised the defendant regarding the implications of such a violation as it related to Ms. Blank Becker's representation of the defendant. The defendant advised that he understood all of the conflicts. Independent Curcio counsel also advised the court, and the defendant confirmed that she had thoroughly explained and discussed with the defendant each of the issues that was the subject of the Curcio hearing. Subsequently, the defendant, at the court's request, explained his understanding of each of the conflicts on the record as explained to him by the court and Curcio counsel. Notably, the court also advised the defendant that he had two lawyers who were not conflicted, Deverell Canick and Thomas Farinella, but that if he waived the conflicts, the defendant would be giving up the right to have Ms. Blank Becker represent the defendant without a conflict of interest. And that means that if the defendant were to be convicted at a trial, the defendant couldn't later claim that the defendant's lawyer, Ms. Becker, wasn't an effective lawyer because she had these conflicts or potential conflicts. And before I continue, let me go back up here and read this note. It says, given the sensitive nature of some of the issues raised, references were made to certain of the facts proffered by the government in the sealed Curcio letters by page and paragraph during the hearing. To the extent a reference was made to one of the sealed Curcio letters, Curcio counsel, who was seated beside the defendant, reread and discussed the paragraph with the defendant off the record. Oh, excuse me. Let's go back up here. Okay, pick back up. Where was I? Okay. So when asked if he understood both of these implications, the defendant responded, "Yes, I do, Your Honor." The defendant advised the court that he waived the conflicts and would continue with Ms. Blank Becker as one of his retained attorneys, which was the biggest mistake. He should have let her ASS go at that moment, but he chose to keep her. So at the conclusion of the colloquy with the defendant, the court found that it had established that Mr. Kelly is fully competent and capable of making an informed decision, that he has been advised by independent counsel, and that his waiver of these potential conflicts is knowing and intelligent, and so I accept the waiver. At trial, the defendant was represented by 4 retained attorneys, Mr. Canick, Ms. Blank Becker, Mr. Farinella, and Mr. Calvin Scholar. During trial, Ariel testified during the government's case in chief, and Mr. Canick conducted the cross-examination of Jane. Now, regarding the Curcio situation, there were people who were saying that, and I believe it's true, I think I did a little research on it, but don't want to quote anything because I could be wrong. But in any event, event. I believe in some Curcio hearings, even if the defendant wants to keep the counsel, the judge has the discretion to say that the act is so egregious that I am not going to allow you to keep this counsel, and they can remove the counsel. So without knowing what was in the Curcio hearing, what these letters were, what statements were made, what conversations Nicole had with Joy, with Azriel, or anybody else, it's hard to say whether the act was so egregious that Donnelly should have removed her anyway. So we don't have that information, so we can't make that judgment. So moving on, B, legal standard. The Sixth Amendment right to effective assistance of counsel generally ensures that an accused may be represented by any attorney who will agree to take his case. A defendant has a correlative right to representation that is free from conflicts of interest. Cardoza versus Rock, quoting George, which was heard in the Second Circuit of 2013, and they were quoting a case, Wood versus Georgia, from 1981, that stated when a defendant's right to choose the counsel he wants conflicts with the right to an attorney of undivided loyalty, the choice as to which right is to take precedence must generally be left to the defendant. District courts have an independent duty to ensure that criminal defendants receive a trial that is fair and does not contravene the Sixth Amendment. Wheat versus United States from 1988. For that reason, when a district court is sufficiently apprised of even the possibility of a conflict of interest, as the court was here, it has a threshold obligation to investigate the facts and details of the attorney's interests to determine whether the attorney in fact suffers from an actual conflict, a potential conflict, or no genuine conflict at all. United States versus Levi, Second Circuit, 1994, and then also see Perez. And then I'm going to go back up again because there was a note, so I want to read all the notes that I catch. The first note says, at the time, a fourth attorney, Calvin Scholar, had not yet entered a notice of appearance as counsel retained by the defendant, so he wasn't a part of the Curcio. And then the next note says the defendant's characterization of Azriel as the government's star witness is not only an exaggeration, but a gross oversimplification of the government's proof at trial, which included the testimony of 50 witnesses and hundreds of exhibits. Well, she may not have been your star witness, but she was very important to this case. But because there is a rule that you cannot bring a RICO, I believe it's the RICO cases, you couldn't bring them unless there was a continuation of the RICO activity within the past 5 years. So it was very important for them to have Azriel and Faith in this case because they needed those current acts in order to be able to go back the 30 years that they did to bring this RICO case against him. So she may not have been your star witness, but she was very important to this case because without her nonsense, you would not have had a RICO case to file. Moving on, let's see. Let me go back down here and pick back up where I left off. Where defense counsel has an actual or potential conflict, the district court must determine whether the conflict is so severe as to require the attorney's disqualification or whether it is a lesser conflict that can be waived in a Curcio hearing. In most cases where a defendant's attorney has a conflict, the defendant may make a knowing and intelligent waiver of his right to a conflict-free lawyer if he decides to continue the representation. United States versus Kane, which was heard in the Second Circuit in 2012, in only rare cases, an attorney's conflict is unwaivable because it is so serious that no rational defendant would have knowingly and intelligently desired the conflicted attorney's representation. Perez Then also see Kane, Schwartz, and then the United States versus Fulton, which was heard in the Second Circuit in 1993, or because the conflict is so severe as to indicate per se that the rendering of effective assistance will be impeded, and that was also from Perez. Indeed, the Second Circuit has recognized only two categories of such per se violations of the Sixth Amendment that are unwaivable, where the defendant's counsel was unlicensed and when the attorney has engaged in the defendant's crimes. And that was from a case called Fulton. An attorney's prior representation of a government witness presents a potential conflict of interest. This is because a lawyer owes an absolute duty of loyalty and confidentiality to both his current and former clients. See United States versus Yanati, which was heard in the Southern District of New York in 2004. United States versus Rahman, which was heard in the Southern District of New York in 1994. Notwithstanding the limitations presented by this continuing duty of loyalty, a defendant can generally waive potential conflicts arising from his attorney's prior representation of a government witness. Let's see, Perez, and then citing Fulton. The Second Circuit has recognized that our cases support allowing waiver of the conflict that arises when an attorney must cross-examine a former client in order to effectively represent a current client. United States versus Oberroy. Such a waiver is allowed because, and in that case was Second Circuit 2003. Although such a conflict might require a defendant to abandon a particular defense or line of questioning, he can be advised as to what he must forego. He can then seek the legal advice of independent counsel and make an informed judgment that balances the alteration in the trial strategy against the perceived effect of having to get a new and perhaps less effective defense counsel. Okay, then Perez, quoting Fulton, when an attorney suffers from a waivable potential or actual conflict, the district court must conduct a cursio hearing to determine whether the defendant would knowingly and intelligently waive the right to conflict-free representation, cursio, and then Levi. So those were two cases. And then let's go back up here and read the notes. Okay, so in representing a current client, a lawyer may not use privileged information obtained from another former client. United States versus James, Second Circuit 1983, and then the United States versus Cunningham, Second Circuit 1982. Moreover, in representing a current client, a lawyer may not ethically attack other clients through cross-examination or argument to the jury. Rahman, which was a supplemental case. Okay, so let's see. The Second Circuit has considered a number of different factors in determining whether a conflict can be waived, including, among other things, 1, whether disqualifying the defendant's chosen counsel would create real prejudice to the defendant based on the length of the representation and or counsel's familiarity with the case. Cunningham. Whether there is a possibility that the attorney, and when I just say the name, that means that we've already gone through the case and they're just quoting a certain portion of that case that they've talked about earlier in this document. 2, whether there is a possibility that the attorney could be called as a witness at the defendant's trial or implicated in the defendant's alleged crimes. 3, whether the continued representation would conflict with the attorney's own personal financial or liberty interests as opposed to the interests of a current or former client. United States versus Jones, which was heard in the Second Circuit in 2004, quoted Schwartz and also Fulton. And then 4, whether if the conflict concerns the interests of another client, the attorney's relationship with other clients is continuing or has been terminated, and that was from Schwartz, Perez. And then Schwartz, one case, Perez, a second case. 5, whether any other current or former client affected by the conflict has initiated or joined in the motion to disqualify defendant's chosen counsel. That was from Cunningham. And 6, the ability of measures that might limit the dangers posed by the conflict, such as restricting an attorney's cross-examination of a former client, and that was also from Cunningham. A defendant challenging his conviction on the ground that he was deprived of his Sixth Amendment right to effective assistance of counsel as the result of a conflict must demonstrate first that the conflict was either unwaivable or that his waiver was not knowing and intelligent, and that was from Schwartz. And second, that he was prejudiced by the conflict, and that was from Levi. In other words, that, but for counsel's unprofessional errors, the result of the proceeding would have been different. And then that was from Fulton, quotation marks omitted. Where a potential conflict exists, courts require that the defendant establish prejudice. Where an actual conflict exists, however, prejudice is presumed and the defendant is required to show only that a lapse in representation resulted from the conflict. United States versus Ariel, Second Circuit, 1986. Quotation marks omitted. A lapse in representation means that some plausible alternative defense strategy or tactic might have been pursued and that the alternative defense was inherently in conflict with or not undertaken due to the attorney's other loyalties or interests. And that was from Levi. In evaluating an actual or potential conflict of interest, while actions of any member of a law firm are imputed to every member of the firm, such conflicts are not imputed on independent trial counsel. See United States versus Stein, EDNY versus United States. And those were cases. Stein was from the Southern District of New York in 2006, and EDNY versus United States was Northern District of New York from 1986. C. Analysis. The defendant alleges that he was denied effective counsel because Ms. Becker purportedly labored under a disabling conflict of interest that was imputed to the entire defense team. The defendant's argument is meritless. It is based on incorrect claims that this conflict was unwaivable and imputed to the entire defense team, which included 3 other independent counsel from different firms who represented him at trial. During the Curcio hearing, the court determined that Ms. Becker may have developed a relationship of trust with Jane and Jocelyn, resulting, and we know that Jane is Ariel, resulting in certain possible conflicts, including creating, among other obligations, a duty of loyalty to them. Assuming that Ms. Becker's relationship with Ariel amounted to an actual conflict, said conflict was clearly waivable. Several factors demonstrate that the conflict was waivable, including that 1. The relationship was brief, limited in scope, and terminated prior to Ariel's cooperation with the government. 2. The relationship did not implicate Ms. Becker's own personal financial or liberty interests. And 3. The defendant was represented by 3 other unconflicted retained counsel who could, and one of whom in fact did, cross-examine Ariel during trial. C. Stein 410 F Supplement 2D at 328, listing factors weighing in favor of finding a waivable conflict, internal citations omitted. The defendant has proffered no facts from which it could be concluded that Ms. Becker's potential conflict amounted to an actual conflict of interest, nor do any of the cases cited by the defendant support the notion that Ms. Becker's conflict was not waivable. Instead, the defendant incorrectly conflates the issue of whether an actual conflict exists with the question of whether the defendant may waive said conflict. As discussed above, it is well established that an actual conflict is not synonymous with an unwaivable conflict. See United States versus Arlington in the Second Circuit 2019. But even though this second conflict was actual, it was also waivable, citing Perez. Indeed, it is the rare exception where an actual conflict cannot be waived by the defendant, and even if the conflict here was actual, it does not constitute one of those rare instances. Rather, the conflict represents one of the lesser conflicts, such as an attorney's representation of two or more defendants or his prior representation of a trial witness that is generally waivable. Also from Perez, holding that a defendant was entitled to waive a conflict created by his counsel's prior representation of another defendant, despite assertions that counsel was blinded by his own substantial self-interest, and finding that counsel had nothing approaching the sort of fiscal self-interest that was present in Schwartz. Considering that there was no indication that counsel had a continuing relationship with or an exceptionally lucrative retainer from the other defendant, see Stein, holding that conflicts arising from trial counsel's prior representation of witnesses were waivable given defendants' willingness to continue with current counsel despite their being barred from cross-examining counsel's former clients as trial, and the defendant's consent to measures that might limit the dangers posed by conflicts, such as current counsel agreeing not to discuss his former clients with any independent attorneys hired to cross-examine them on conflicted counsel's behalf. Arlington. Although counsel's conflict compromised his ability to be a zealous advocate for the defendant, it was nonetheless waivable. We have generally found that this type of conflict is waivable, internal citations omitted. And then I'm going to go back up here because there were some notes on the previous page. Let's see, 15. The defendants claim that Ariel may have obtained privileged information from Becker that was adverse to the defendant, completely misconstrues the government's representations on this point, and the assertion that Ariel most certainly passed information subject to attorney-client privilege between Ms. Blank Becker and the defendant is not only speculative but patently false. Likewise, there is no basis to suggest, as the defendant does, that Ms. Blank Becker's interactions with Ariel, even if they amounted to an attorney-client relationship, were an attempt to influence a government witness on behalf of her client. And then 16, notably, the cases cited by the defendant support only the principle that counsel's representation of both the defendant and a witness generally creates an actual conflict, not that such conflict is unwaivable. In fact, the cases cited by the defendant demonstrate quite the opposite. And then they talk about the different cases that Bongine presented, noting that similar conflict may have been waivable and remanding case for determination as to whether a conflict in fact existed. Then they talk about, I'm not going to read all this. Petitioner has failed to allege facts supporting a conclusion that any of the potential areas of conflict arising when an attorney was previously represented an important witness for the prosecution existed in this case. So they're basically quoting some of the stuff that she quoted in her document. So let me see. Pick up where I was. Okay, in addition, any conflict related to Ms. Blank Becker's conflict arising from any assumed attorney-client relationship with Ariel was not imputed to the defendant's other counsel. The defendant's reliance on United States versus Stein in support of his claim to the contrary is misplaced. While Stein held that counsel's conflict was imputed to the other attorneys in counsel's small firm, independent counsel had no such conflict. See Stein, holding attorneys' conflict from prior representation of trial witness waivable because, among other things, independent attorneys could be hired to cross-examine these witnesses on conflicted counsel's behalf. And that was part of the Stein case. And I know it's kind of confusing how they quote so much from these other cases and then go right into the what's happening in this case, and it may all seem to be running together. So now it picks back up and says Ms. Blank Becker is a solo practitioner, and the defendants, other counsels, each have their own independent practices. Thus, Messrs. Canick, Farinella, and Scholar were not members of any firm with Ms. Blank Becker and remained unconflicted. And then they talk about the case EDNY, finding that conflict was not imputed to a co-counsel, given that the record did not indicate a general partnership relationship between the attorneys extending beyond the representation of petitioner himself. And so that was from the EDNY case. Then she picks up again, given that Mr. Canick, one of the defendant's 3 independent, unconflicted counsel, conducted a vigorous cross-examination of Ariel at trial, the defendant was not shown that a lapse in representation resulted from the conflict. Rizzo at 58, even assuming the circumstances presented an actual conflict, nor can the defendant demonstrate that he was prejudiced in any way by Ms. Blank Becker's conflict if it was only a potential conflict. So even though they don't work for the same firms, they were still technically on the same legal team. So she could have shared information with them. I don't understand how they're trying to say that because they weren't in the same law firm that she couldn't have shared information with them. That makes no sense. But moving on, there can also be no question that the defendant was fully advised of the implications and consequences of the conflict between Ms. Blank Becker's purported representation of Ariel. After being so advised, the defendant knowingly and intentionally waived the conflict and chose to keep Ms. Blank Becker as one of his attorneys. While Ms. Blank Becker's conflict prevented her from cross-examining Ariel at trial and from disclosing any privileged information obtained, if any, from Ariel to the defendant or the defendant's other counsel, the defendant was advised of those consequences and was well within his constitutional rights to choose to continue to retain Ms. Blank Becker. And then they quote Arrington again and say a reasonable defendant may decide to retain trusted attorney even at the risk of losing those advantages after being properly informed of the risk and benefits of the consequences of that decision. Finally, with respect to the defendant's claim that Ms. Blank Becker suffered from a conflict under Fulton, the defendant is wrong. Again, the defendant conflates 2 separate issues addressed by the court during the Curcio hearing. As set forth in the June 14, 2021 sealed letter, in an abundance of caution, the government expeditiously alerted the court to speculative information it had received from the defendant's former attorneys related to Jocelyn and Ms. Blank Becker. See the doggone Greenberg stirring the pot. Jocelyn did not make any such allegations, nor did the government intend to or ultimately call Jocelyn as a witness at trial. Thus, even if there existed the possibility of a conflict under Fulton, no conflict was likely to or did in fact arise. None of the dangers outlined in Fulton therefore existed here. Then see Fulton, noting that the allegations were by a witness who was testifying against the defendant at trial, making it a different order of magnitude from other conflicts. Moreover, in the unlikely event that Jocelyn was to be called as a witness at trial by the government at the time, as set forth in Fulton, the per se rule advocated by the defendant applies only where the alleged criminal conduct is true or of the nature that it should be treated as true, not where the allegation is false. Therefore, in order to prevail on this claim, the defendant must show prejudice. Given the lack of evidence before the court regarding the alleged conduct, there was no basis to treat the allegation as true. And then they say, see something at 613, stating that the considerations relating to the per se unwaivable conflict found in Fulton do not apply if the allegations are clearly false. And then there was a note on the previous page that said, in any event, even if the allegations were deemed to be true, Jocelyn was not called as a witness at trial. Okay, then continuing on, thus, if a district court holds a full hearing and can definitively rule out the possibility that the allegations are true, a meaningful waiver is possible since the falsely accused attorney is conflicted only to the extent that she cannot cross-examine the witness regarding the false allegations. As discussed above, the defendant had 3 other independent retained counsel, including Mr. Canick, who acted as lead attorney at trial and could have cross-examined Jocelyn if she had been called as a witness. The defendant, therefore, was not and cannot provide any evidence that an actual conflict existed, or that if a potential or actual conflict did exist, that a lapse in representation resulted from, or that he was prejudiced in any way by the conflict. Accordingly, this court should deny the defendant's motion in its entirety. Then there's another note on the bottom of the page that says, to the extent the defendant's reference to misconduct implicating a so-called Fulton conflict also concerns the potential ethical violation by Ms. Blankbecker for contacting Ariel and Jocelyn while they were represented by counsel, such a violation would not be the type of crime or misconduct sufficiently related to the crimes with which the defendant was charged as contemplated in Fulton. And then they quote from Fulton, of course, the per se rule does not apply anytime a court learns that an attorney may have committed a crime. The attorney's alleged criminal activity must be sufficiently related to the charged crimes to create a real possibility that the attorney's vigorous defense of his client will be compromised. Conclusion. Based on the foregoing, the defendant's motion for a new trial should be denied. And then y'all know them hookers who signed it, okay? Who wrote it. Okay. So, I think this was a pretty good response. They did cite a lot of case law that was pretty redundant and could have shortened this by about 15 pages. I don't know. What do you guys think? We already know that Judge Donnelly is going to side with the prosecution, irregardless of, how this plays out. She's not going to grant a new trial, and she's not going to do a acquittal. And then we also have to keep in mind that a lot of this is based on case law. And so they put all this information in there, thereby confusing the person that's reading it, because then you have to sort between what was fact, what actually happened in this case and what they're quoting in case law. And when you just look at these little quotes that they're pulling from what is probably hundreds of pages of documents from the hearing itself, just to apply the portions that fit their scenario. And the defense does the same thing. They pull, pieces from the cases that they have that they say support what they are talking about. Now, I am not sure if Bonjean will get to respond to this, or if it's like she filed the motion, they respond, and then Donnelly makes her decision. But I still believe that all of this is a formality, that she doesn't really actually think that Donnelly is going to entertain any of this, that she's going to overturn the verdict, or that she is going to grant a new trial. But she needs all this on the record to go before the Second Circuit of Appeal. Now, what I would be interested in knowing is, once she goes to the Second Circuit of Appeal and argue the case to try, because first of all, there's no guarantee that the Second Circuit is even going to hear the case. They could look at these documents and determine that they don't want to hear the case, that there isn't enough cause for them to hear the case. But when she goes before them to present, her findings and to get them to consider the case, will she bring out information that counters what the government has put in this document? Because when you're reading this document and then you look at the documents, the motion that she filed, it's easy to say, well, okay, the government has her, like they responded to every single thing, and that there's no way that this is appealable. But there may be more information that Bonjean is holding on to, like she's not putting all her eggs in one basket, and that there will be a counter to what is put here. So that would be interesting to see. Now, this is already 2 hours long. There's still another document that they filed that is over 100 pages. And Lord knows, I don't know when I'm going to get that to you guys. I know I have a project that I'm working on that is due tomorrow, I believe around 6 o'clock. So I may start working on that other document tomorrow evening. So you may not get that until Thursday evening, but we'll see how it all plays out. But anyway, go ahead, leave your comments below. Let me know what you think. Is this looking good for an appeal? Do you think that the government dotted all their I's and crossed all their T's and shot down everything that Bonjean had to say in her motions? Or do you think that Bonjean was being very limited in what she was saying in her motions because she has more information that she can use to counter this? Let me know in the comments. If you haven't subscribed to the channel, please do so, and also rate the video once you're finished watching it. And until the next time, I shall talk to you guys later. Bye-bye.